got a couple of questions. Could you explain a little bit more about the 3 feet per day?
Well, I'm not prepared to engage in a mathematical discussion, but I think that it's important to understand that the hydraulic conductivity of soils absolutely relates to how fast water can move through the soil, but it also depends largely on the gradient and a number of other factors. So to say that 10 to the minus 3 in any circumstance means that 3 feet, that a contaminant can move 3 feet per day in soil is not an accurate statement. You don't have enough information to say that.
So another question I have is, there was a statement saying that we have the weakest rules compared to India and possibly Mississippi. Would you agree with that?
I don't believe that for a moment. And in fact, when we went through the rulemaking in December, the process with the Joint Legislative Committee on Administrative Rules, we provided a detailed response to the original preliminary objection, and we also provided...
Which was in November, right?
The objection was in November, that's correct, and we went back to the Joint Legislative Committee in December, and we provided about a week ahead of time, or a couple weeks ahead of time, a written response to that preliminary objection, which we were prepared to speak to at that hearing in December. And that included not only our letter, but some supporting documentation, as well as a memo or a letter to the committee that explained almost 30 areas where we had strengthened the rules prior, compared to the previous rules. And actually, I have copies of that today, just for reference. I'll leave with the committee so that you know what our response was at that time.
And there were no recommendations of changes, if I recall.
The committee elected to find that we had completed our rulemaking assignment consistent with the law, and they approved the rules.
There was a statement saying that we could build a landfill anywhere in the state. Is that correct?
No, that is not correct. Again, it's what we tried to discuss with folks who've had concerns about these rules is that you have to look at the rules in their entirety. And one of the key things that folks tend to leave out, and that's actually detailed in the response we made to the Joint Legislative Committee, is that there are additional provisions beyond just a specific 500-foot setback to surface water and such. And one of the key provisions is it said you cannot site a landfill, and we won't permit a landfill unless you site it such that a release from the facility can be detected, investigated, and remediated prior to groundwater contamination above standards reaching the property line of the facility, and also prior to contaminants migrating to surface water.
Thursday morning, June 13th, 2024, Ammonoosuc River. That is the NCES Landfill side of the river, and that is the Seep. Here we are at the Seep. NCES Landfill. You see the markers, and there's the runoff, surface water runoff into the Ammonoosuc River.
You have to be able to detect, investigate, and remediate that.
Thursday morning, around 11:45 a.m., August 15th, 2024, getting ready to cross the Ammonoosuc River again over to the NCES Landfill Seep to get another test sample for PFAS contaminants being discharged from the NCES landfill property, surface water runoff into the Ammonoosuc River. Okay, so here I am, across the river. NCES Landfill Seep, surface water discharge. Boy, you can see it up there coming down as well. And you can see it through there. Trying to get a different angle. Sure is coming off of there, though. I wanted to add some footage of that water just cascading down along the Seep to where I was testing.
Prior. So that is not it's not something you can just look at and say that's X feet. You have to look at the site-specific circumstances at a given proposed facility, but that's why we have hydrogeologists and engineers on staff to evaluate a proposal like that, and we require licensed professionals, engineers and hydrologists, to prepare the application materials that make that argument. So there's professional staff review, both from the standpoint of the applicant as well as by the agency when it reviews the application, to make sure that those criteria are met. Those are very stringent criteria, and they're likely to preclude a number of sightings from occurring. But we believe that they should be there, and that's why they were written that way, and that they are protective.
Originally, there was a 200-foot setback, and there was a complaint that was very arbitrary,
right?
If I recall correctly. And so it was bumped up to approximately 500 feet, correct?
That's correct. There's a specific setback requirement that any landfill footprint be at least 500 feet from surface water. So that's you can look at the map and figure that out. You don't need to know anything else about the facility, but that is just one criteria that we apply. So if you don't make that, you don't get siting. But if you meet that, then we go to that much more detailed analysis of how contaminants would move through the formation, how fast they would do that, and whether they would meet the standard of being able to be detected and remediated prior to reaching the property line and groundwater, or prior to reaching the surface water.
So there's a 1,500 foot setback based upon this bill, from what I understand.
Right.
I'm not sure, is that based on science, or is that based on arbitrary, like the 200?
I did not prepare that, so I don't know what it's based on.
Okay.
The agency did not, that's proposed in the bill, but the agency did not propose that.
On page 3, on line 18, it turns the may to a shall deny a permit. The department shall deny a permit under this section. Are you familiar? Did you look at this at all?
I'm familiar with it. We are not taking a position on this bill, but I'm familiar with that provision.
Does that change the dynamics substantially?
I think what it means is that, as I understand it, if an applicant or one of its officers had been convicted of a felony or pled guilty to a felony in the previous 5 years, the agency would need to deny the permit, as opposed to having some discretion to determine whether that was necessary or not.
Could smoking pot be considered a felony? Just teasing. Oh, that's not, I shouldn't have gone there. But anyway, a felony, you may or you may not, it doesn't have anything to do with the value of the application at all. It just has to do with their record as an individual, correct?
I just testified on a bill about this, the requirement to do background checks over in the House E&A committee this morning. And in fact, we've had, for 4 decades, we've had provision in the law that says that applicants for either solid waste or hazardous waste facility permits must subject themselves to a criminal background check. And the purpose for that is to ensure that folks who are involved in or head up companies that manage these facilities do not have criminal records.
So one final question from me, and I don't know if you folks have any questions, but in the previous hearing, the one, and I'm going to have him come up, Mr. Bay, mentioned that if this goes through with the language as is, it could change the lifespan from 2035 to 2028. Where in this bill would that make that change? Or I could ask Mr. Bay.
I think it would be best to ask him. I'm
Yeah.
not sure how that is.
Questions from the committee? Yes.
Go ahead, I hate to weigh in.
No,
Here.
we appreciate you a lot.
Am I correct that different kinds of soils would allow stuff to flow through them at different rates?
Absolutely.
And so is it unreasonable then? I'm sorry, Paula.
No, you're right.
Is it unreasonable to consider the time of travel, because that then says the department has to consider that type of soil?
No, I don't think it's unreasonable to consider the time of travel, and the provisions of the rules that I just described in response to Senator Vart's question does that. It does it a different way than is proposed in 707, but it does that.
Thank you.
I do have one other question. The mattresses came up into a previous hearing, and I thought it was illegal for mattresses to cross the borders. Is that correct? I mean, we're not supposed to receive mattresses from out of state, from what I understand.
Not specifically, or not absolutely. We do have a law that says that if a particular waste is prohibited from landfill disposal in another state, that it's not to be sent here for disposal. So it would depend on which state it came from.
Henry, don't go anywhere. I need you. All right. I'm going to have you next. Yeah, I know. Oh, don't you go anywhere. All right. He just did. It's too bad. No further questions? Thank you very much. Appreciate it.
You're welcome.